Right. Well, it's 9:03. We'll go ahead and get started. Good morning, everybody, and welcome to the September 2024 edition of the Burr Morning Show. I'm Bryance Metheny. I'm the chair of the Labor and Employment Practice Group here at Burr and with me today is Matt Scully, my trusty sidekick, the Robin to my Batman, if you will. We'll be with you for the next hour or so, I think. Usually, we try to get these morning shows done in a 30-45 minute range, but there's a lot of material to cover today, and so hopefully we can knock this out. My hope is that we'll get through this material a little bit quicker so that we have some time to answer the questions that this sort of material inevitably generates. So if you've got a question as we go through the presentation, type it in the chat box. We'll circle back to it at the end if we don't see it right away, but we'll try as best we can as we go through some of the hypotheticals that we're going to discuss today to get on those questions. And if you type one out and we don't get to it, I don't, Matt probably doesn't have anything to do for the rest of the day, so he'll get back to you with all of your answers if we don't get to all of the questions in the chat. Our topic today, frankly, it didn't seem all that exciting to us when we picked it. We just thought it might be time for a refresher on leave management since, for both Matt and I and a lot of the lawyers in our group, those are the questions that our clients really call us about the most on a day-to-day basis. Some other issues that we've gone over in these morning shows and other webinars that we've done, those maybe are the bigger ticket items. They're a little bit more complex. Maybe they're more exciting, but really the day-to-day leave issues are what seems to kind of vex HR professionals the most. And that makes sense. These laws, the various laws that we're going to be going over are highly regulated. They're always evolving, and they overlap with each other to a significant degree. Not a day goes past that someone in my office isn't saying to a client, "Okay, but did you consider the ADA? Did you think about the FMLA?" And some days I'll get a call, and I'm sure Matt does too, from a panic-stricken HR manager who presents something along the lines of a law school exam question that triggers all of these laws at the same time. Like, for example, you see on the screen, pregnant employee has a potential work injury that caused a serious health condition under the FMLA, a disability under the ADA, could implicate your STD, LTD policies, and maybe your paid time off policies. Employee has told us that doesn't know how long she's going to be out, doesn't have a doctor's note, but needs time off. What do you do? These are the sorts of questions that come up every day for our clients, and I'm sure for you. I am not going to attempt to answer this "what do you do" question right now, because honestly, I'm not even entirely sure. That would take a lot of thought to go through a complex situation like that. But it does give us a pretty good sense of the environment that these issues can arise in and how they have the potential to overlap all the time in a very significant way. Sometimes, we feel like we have to use dry erase boards, mugshots, newspaper articles, multi-directional arrows, like we're on an episode of The Wire, just to understand all the implications. And that's really a good place to start with this overlap. We're going to move through this section as quickly as we can, but we feel like it's important to identify the various major leave laws that are at play here. And note that I said major, because we couldn't possibly have time to dig into some of the less used statutes when it comes to leave management, like USERRA and all the different state laws that can impose substantial leave obligations on employers. But we think it's important to have some reminders about the various laws and what they cover, so that will give us some context for the hypotheticals and then some of the do's and don'ts we're going to get to at the end, as Matt walks us through some of this material in just a few minutes. We're going to start with the Americans with Disabilities Act, sort of the linchpin for leave management. So what is the ADA really about? It's broader than just leave issues, of course. It deals with unlawful medical inquiries, disability discrimination, reasonable accommodations that can mean, anything from the modification of a work site to, time off. Disabilities are a complicated thing to think about. For the most part, what we advise our clients is if somebody presents to you with a medical condition, assume that it constitutes a disability when you work through the issue. A disability is anything that limits one or more major life activities that can include things as basic as hearing, walking, concentrating, any major bodily function. And so, when we're thinking about how this comes up within the context of leave management, it is, well, we have to sort of assume that if someone has any kind of medical condition, we need to consider that as we think about the leave that might be available. Because what it triggers is reasonable accommodations. When are they required? If an employee informs the employer of a need for accommodation, or the employer knows of a disability, then we have potentially an obligation to engage in an interactive process with that employee to determine whether the accommodation is appropriate. The burden's on the employee, and that's something that we always sort of fall back on when we're advising clients, and you're considering on a day-to-day basis whether or not I need to provide an accommodation. But remember, there's no magic words that are required. The employee doesn't need to walk into your office and say, I hereby demand accommodation. The fact that we know of a disability and there is a limitation on the employee's ability to successfully perform the job can trigger that obligation to engage in an interactive process and consider whether an accommodation might exist. Accommodations themselves, not the easiest thing to work through, right? An accommodation is anything that would enable the employee to perform the essential functions of their job, absent undue hardship. Now, one of the ways that this comes up in leave management is, remember, an accommodation is something that enables them to perform the essential functions of their job. It's not an accommodation that allows them to require us to modify the job or to make them not do the job. An accommodation is something that enables them to perform the job, absent undue hardship. But a lot of courts, and the EEOC in particular, have concluded that an accommodation can be a short-term leave. Not an indefinite, unknown leave, but a short-term, fixed date for return type of leave. And so that raises a lot of issues when it comes to leave management and the way these laws can overlap and work together. What's important is that we're not required to provide the exact accommodation that's requested. We have to provide an accommodation that enables them to perform the essential functions. Doesn't have to be specifically what they request if it meets those needs. So that's the ADA. Now let's talk a little bit about, the other major law that affects employee leave and leave management. The FMLA is something that we're all familiar with. I'm not going to say anything that you don't already know in the next couple of minutes, but let's refresh and think about how these things overlap with each other, how they interact. The FMLA requires up to 12 weeks of leave for eligible employees, and we know, the things that make a person eligible: serious health conditions, new child, family member, serious health condition. Recalling, of course, that it's 12 weeks of unpaid leave. And that, is over a period of time. There's a 12-month period that we're looking at for that 12 weeks of leave. And so when we're thinking about this in the context of leave management, it's really important, if we have an employee that presents with a qualifying condition under the FMLA, that we treat it as such, so that we can reduce down the potential availability that employee has to take this FMLA, to reduce our obligations, to give us more options when an employee presents with a need for an extended leave. Employees are eligible if they've worked 1,250 hours over the last 12 months for the same employer that has 50 employees within a 75-mile radius. Hopefully, all of you have already made those determinations, but it's really critical that we know the work sites that we have that are covered by the FMLA and the employees who are eligible. So many times I get calls from employers that are thinking about leave issues and believing themselves to be burdened by the FMLA, to be restricted in what they can do. And then, we talk through it, we find out the employees in their probationary period. They've only been there for 40 days. Well, they're not eligible. We have to sort of remember what all those elements are so that we can give, thorough thought to all of the potential issues. Notice is, sort of a uh, yes, if foreseeable, the employee must give 30 days notice. If unforeseeable, as soon as practical. Most courts, they're gonna think that an employee has given us sufficient notice if they've given us any notice before they go out on leave. And so we don't want to rely on that, but we do want to make sure our employees understand it's their obligation to give us notice. The leave can be paid or unpaid. That's up to us, but the law only requires that we provide 12 weeks of unpaid leave. We can use other PTO and require it to be used at the same time as the leave that's taken under the FMLA. But that's something that needs to be in our policies. And so, one of the things I would encourage all of you as part of your leave management process is to review your policies and make sure that we are designating whether or not and how much PTO must be used in connection with an FMLA absence. Always remembering, and this is the hardest part, when they return, they have to be restored to the same or equivalent job position. This is frankly the part of the rule that makes it hardest for us to comply with in certain work environments. You can imagine that in a heavy industrial manufacturing environment where the person has to be there to do this particular job and they go out on leave, well, somebody else has to do it while they're gone. What happens when they come back? Where does that person go? So these are the challenges that we face as part of our leave management. So that's FMLA. We have ADA, we have FMLA. The newest one is the Pregnant Workers Fairness Act. We've actually had morning shows on the PWFA already. But what we have to think about is it's the way in which it has begun to overlap with the ADA and with FMLA to just present additional challenges for leave management. Now, of course, it's limited in scope. You're not obviously going to have issues with workers under the Pregnant Workers Fairness Act who aren't pregnant. So that limits the population that we have to deal with. But it's a very extensive, somewhat burdensome statute that, again, just became the law this summer. It requires reasonable accommodations for any known limitations related to pregnancy, to childbirth, or any related medical condition. All that the employee really has to do is just say, I have a limitation and I need something differently done at work. And we have to begin the interactive process to determine whether an accommodation is appropriate here. The PWFA specifically prohibits retaliation. It prohibits requiring an employee to take leave if another accommodation is available. So, we're talking about leave management here, but employees also sometimes don't want to take a leave that we want them to take because we think they're not able to adequately perform the job, with their medical condition. We can't require them to take leave if something else is available to accommodate. And then we can't deny them opportunities based on the need to make an accommodation. If there's a promotion issue, if there's, some sort of benefit at work that they're eligible for, we can't deny that simply because we've had to make an accommodation because they're pregnant. So it's not just pregnancy, it's childbirth, it's conditions related to pregnancy and childbirth. The important thing to remember here, in the past, before the PWFA was passed, we evaluated this under the ADA. Is there a disability? And pregnancy itself wasn't a disability under the ADA. This law says, a pregnant worker is automatically protected by the same sorts of accommodation requirements and obligations that they would have had if they had been able to prove they were disabled under the ADA. So it is, vastly expands the universe of options that are available to employees with respect to pregnancy accommodations, things like that. I was reading this morning, the EEOC has filed its first lawsuit under the PWFA. So we're off and running. Soon we're going to start to find out what the courts view, how they view this law and some of the obligations that it imposes. Right now, we're sort of just flying blind on the regulations themselves, but we're going to start getting some case law here pretty soon that's going to help us understand it a little bit better. So that's 3 of the laws that overlap and interact. Workers' comp is involved here as well. And workers' comp is something that is a little bit sort of outside of the traditional leave management arena, but we have to remember it, especially, in certain states where there are more extensive obligations than there are in a lot of the southern states that are within Burr's footprint. Employees who suffer from an on-the-job injury are covered by workers' comp. So they're protected by the workers' compensation laws. The employee, benefits, things like medical benefits, comp benefits, protection from retaliation, those are the things that an employee benefits from if they've had an on-the-job injury. It's, something, again, I mentioned earlier, if an employee has a serious health condition that has made them a qualifying employee under the FMLA, even if that was as a result of an on-the-job injury, we need to treat that as an FMLA leave so that it can run concurrently with the absence that's caused by this on-the-job injury. Again, this is not to punish or penalize an employee, but it's to ensure that we have all the universe of options available to us when an employee is taking an extended leave. What we don't want is to be in a position where we have not tracked and treated an on-the-job injury as an FMLA absence. 12 weeks passed, and now they apply for FMLA, and we aren't able to then use that previous time to sort of, draw a line and say, well, all right, well, here is where your available statutory leave expired. Now we have options. And then, finally, I guess, the short-term and long-term disability implications. An employer does not have to provide short-term or long-term disability, but many do. And so when we do, it creates a level of, confusion. Some folks get a little bit unclear on what short-term disability and long-term disability do with respect to leave management. So, the question is, what are the benefits that we're providing? These plans are different for every client that we represent. They're tailored by the employer. They can be employee contribution pay based. They can be the employer pays for all of it. At some level, what it provides is benefits that are usually a little bit less than 100% of lost wages that occur during leave. What it does is it makes being out more attractive to an employee. When we have a short-term disability plan, it's just going to be more likely that an employee is going to be absent and try to take advantage of the STD so that they can get paid for not having to work. So when we think about, leave abuse, that's often where it comes into play. Now, again, STD can be, and most often will run concurrently with the FMLA. It's difficult to imagine a scenario where someone is covered by an STD policy, but doesn't have a serious health condition that would trigger the FMLA. So, again, we need to think about how can we use FMLA and its, the ability for it to run concurrently while someone is taking short-term disability to make sure that we've wrapped our arms around the universe of options that are available. STD, LTD is not job protected leave, not by itself. Okay. And that's the thing that we, have to take into account here. The mere fact that someone is on short-term disability does not protect their job. What might protect their job is the fact that they also have a qualifying condition under the FMLA, whether we have designated as such or not. And that's where people can run into trouble. Someone goes out, they're on STD, something fell through the cracks and we didn't have it qualified as an FMLA event. It isn't running concurrently, and the employee, wants to return or is ready to return, and it's not job protected. We don't have to necessarily return them, except that, well, yeah, we do, because this should have been treated as an FMLA event, and that would have protected their job. So we have to kind of factor in all of the ways in which those laws can overlap. And then, I guess, finally is PTO. Employer provided, right? Most states don't require an employer to provide PTO. I know very few businesses that don't offer PTO to their employees. So when we choose to provide PTO, we have to comply with the state laws dealing with accrual, payout on termination, those kind of things, right? But there are rules. And it's really important that all of us on this call, the HR professionals, look at your policies and understand, all right, what am I obligated to do based on my existing policy? Do I like this policy? Are things about it that I should or want to change so that I can better understand and have a grasp of what this PTO actually provides for people? If it's in our policy, and in most of the states in which anyone on this call is working, if it's in our policy, we have to follow the policy. That's what creates the contract rights. But otherwise, it's up to us to decide. We can determine what needs to be in our policy with respect to things like accrual and payout, but we have to follow it because we've created a contract with the existence of that policy. We can require employees to use PTO while they're on any type of FMLA or ADA leave. And we can require it to be exhausted. We can require them to use some portion of PTO during that leave. So, when we're thinking about all of the ways in which these interact, we've got, is this a reasonable accommodation to provide leave? Am I required to provide it because it's FMLA qualifying? I have PTO. Should I require them to use PTO while they're, engaged in this absence from work? We have to think about all those things at the same time, with that set of issues. One of the things that's really come up a lot for me lately is, unlimited PTO or discretionary time off, where a lot of, especially major employers, have determined I am not going to carry the accrual for payout on PTO on my balance sheet. And to avoid that, what I'm going to do is I'm going to say, exempt level employees, for example, get unlimited PTO. That, there is no cap, therefore there's no accrual on my PTO plan. And this is, workable. And in some situations, it works really well. But in others, where we aren't thinking about the ways in which these unlimited PTO policies interact with things like FMLA. So, for example, you have an unlimited PTO policy. You require employees to use their paid time off while they are, taking FMLA. That policy is not drafted carefully. You could end up in a situation where you have just made all FMLA paid rather than unpaid because you have an unlimited PTO policy that runs concurrently. So, we want to make sure if you have that type of plan or policy or just practice, that we're separating out and being very clear in the distinctions between personal time off, that is usually what unlimited and discretionary PTO should be used for, and sick leave, something that is related to a medical condition or the treatment of a family member, which is different from a personal unlimited PTO. And then finally, I'm going to let Matt take over. General leave of absence policies. And almost all of the clients that I represent have something in their handbook that is kind of a catch-all. PTO, FMLA, workers' comp, all these things that are, that make employees available that make leave available to our employees, but they don't necessarily cover this particular situation. So I have a leave of absence policy that's discretionary. The problem that we run into here, and happens all the time, when we have these general leave of absence policies, we have a tendency to allow the good employee, the ones we like, to take extended leaves because we want them back, because we don't want to lose this person. Maybe somebody had a heart condition or knee surgery and it's going to take a little longer to recover. And so we make them eligible for this general leave of absence policy. But then we've got a complainer, a problem employee. Maybe it's an employee that's been out there stirring up, trying to organize a union, and they go out and they want to, they ask for an extended leave of absence under our general policies, and we say no. We have to be cautious about discrimination in the application of these types of policies. They can create real problems and have because I've litigated these cases, have created real problems in the execution of this leave of absence policy. So we have to think about how those things all interact and overlap with each other. So now Matt is going to talk us through a few hypotheticals that I think are interesting and can help us.
Great, thanks, Bryance. And if you can tell, we've broken this up into two parts. The first part is the laws that are out there that need to be considered, and the second part will be examples. We couldn't do the examples without everyone knowing the laws, and you're probably familiar with a lot of laws we touched upon, but one of the hard parts is thinking about them each time. When your person comes in with a workers' comp issue, or you think about ADA, FMLA. When your person comes in with an FMLA issue, are you thinking about ADA? And how they all interact together. There's overlap, there's some conflicting responsibilities at times. And so we wanted to start with the background on not every law you will need to consider, but generally the world of laws that you'll need to consider when someone comes to you with a leave request. So here's the first hypothetical. Underperforming team member still in probationary period, has an outpatient medical procedure, but needs to miss work due to an infection he caught at the hospital. Employee does not know when he will return, says it will be a couple of weeks, but offers he could probably work from home. Some of you may be nodding your head and you've had something like this come up. Here are some questions we want to talk through on this, and we have a chat. And please, if there's other parts you want to discuss or other facts you'd like to consider, if we want to put in this scenario, we'd be happy to do so. But let's start with number one. Does it matter this employee is on his probationary period? No. Of course, there's the Family Medical Leave Act, and you have to be employed for a certain time period to be eligible. But the fact alone this person's on a probationary period will not matter for the ADA, and it will not matter for workers' comp. Where we see this come up is you've got it. The question is, when there's a 10-year employee, first time they've called you about a medical condition, most employers are more open to working with that employee. Where we get calls about this is the underperforming employee a week into work and they're already having issues, and the employer wants to know, well, do I have to keep this person? It's just not working out. And what we have to always remind people is that the ADA, workers' comp, and maybe some other policies will apply, even though this is a new employee. Can the employee use your policies, paid time off? This is not regulated by federal law. So you can draft your policies as you want. You can have a policy that says during the probationary period, employees are not eligible for leave. During the probationary period, employees only have one paid day off. You can draft the policies as you want. But if you have a policy that says everyone gets a certain amount of vacation, their first day of work, and it may not even be that clear, it just says employees in your first year, you receive 10 days of vacation, for example. This employee, if that's how your policy is written, can make a very good case that I have these 10 days and I can use them now because that's what your policy says. And where we get into problem areas is if you deny this employee that paid time off, but you've let other employees use it, or it's not consistent with your policies, and this employee could later say, well, you treat me differently because of my disability. What are your FMLA obligations? Does this fall under FMLA? The situation sounds like it would. Out of work, probably hospitalization, certainly can't work for a long time period. If it's infection, there'll probably be a course of treatment. But since this employee is so new, 90-day probationary period, this employee will not have worked the time period required to be eligible for FMLA. So as you have your flow chart on these things, you can cross off FMLA. This is not an FMLA issue right now. What are your STD and LTD obligations, if any? As Bryance mentioned, STD and LTD is not job protected. So it doesn't cause us attorneys as much concern whether it's STD or LTD, because we're not dealing with legal claims if you terminate someone who's used STD or LTD. Those people have a third-party administrator who does STD and LTD, and that's something they can handle. They'll know their rules, they'll know who's eligible, and that's something that you can push off your plate. What we tell people is people who've signed up for this, you want to let them know they've signed up for and what their rights are. Usually new hire paperwork or something like that. Do you have to tell every employee that's feeling sick or having medical issues, sign up for STD, sign up for LTD, you can get paid? You don't have to. There's not a legal requirement you have to do that. You don't want to lie, you don't want to mislead, But if you put them on notice of their rights, they know they can pursue STD. But we have a lot of employers who that's part of their paperwork they give employees who need time off. You can use STD, you can use LTD, and there's certainly nothing wrong with that. So you have a little discretion in that sense. What are your ADA obligations? So this is a big one here for this fact pattern. New employee, not FMLA, not workers' comp, not a work injury, pay time off policies. We can deal with those. STD, LTD, that's going to be a third party administrator. We can push it off to them. But this is likely going to be a disability on the ADA, possibly. We don't know, though. We'll need more facts. And what key facts we'll need is the duration, the severity of this. And how do you get that? Do you have to take the employee's word for it? No. ADA gives us tools. And one of the tools is we can require a doctor's note. We always recommend getting a doctor's note. One, because you need it. Employees, it's a good practice to require some sort of third party to document that there really are issues needing an accommodation. And two, we don't want inconsistent application of work rules. If you let your long-term employee take time off, extended time off for a medical condition without a doctor's note, then you have to explain later why you treated this new employee differently, and is it because of the medical condition that employee had? So what can you do? There's two options. There's two. Let's start with this. There's two types of notes we see. One is a general, this employee needs time off, and then there's a more specific. And the more specific we like, and you can tell the employee to give you a more specific note. And that's an important point. When you get the note, scribbled note, needs to be off work 2 weeks, you don't necessarily have to accept that. Because what you need to know is there a medical condition, and can the person perform the essential job functions? That's information you need, and it's information you're entitled to. And we have tools, we have documents we can give employers where you can ask that question. You can say, got your note, thank you, but we need more information. Here's what we need, and you give them a letter and you say, we need to know this, we need to know how long, duration, how it impacts you, what you can do. We're going to attach a job description. We need your doctor to tell us if you can perform these job functions, and even have your doctor tell us if an accommodation is needed and what it would be.
Hey, Matt, one thing on this particular issue, this is an effective way to deal with the suspected malingerer, someone that you think is abusing leave, is to require them to jump through as many hoops as possible. This is something that's not easy for our employee to necessarily obtain. And if it's not worth it to them, they might not go get it. So, these sort of paperwork based, putting an obligation, putting a burden on the employee to go gather information is a way that you can cut down on some of the abuse.
Yeah. And you have so the EOC, and EOC, it's not the law, of course, determine the law, but they've taken the position, normally this individual should be entitled to go to their doctor and get this information. But if the doctor doesn't give you the information you need, or it's not clear, and you let the employee know that, you can send the person to a doctor of your choosing, but you should pay for that. Now, that's the EOC. Could you be more aggressive? Could you send the employee to a doctor of your choosing and pay for it? I think we could justify that if you wanted to. Usually it's easier to tell the employee to do it. So it's not on you. This isn't a new obligation of you. Say, employee, we need this information to make this decision. Now, the FMLA has very specific timing requirements on when things have to happen. The ADA doesn't. So we want you to get this, and this is number 10. We want you to get this information to the employee as quickly as possible, what you need, and give a reasonable time to get it back. What's reasonable depends on the circumstances. If someone's extremely sick in the hospital, maybe not push that. But if someone is going to see their doctor in 2 days, say, we'll need this in 2 days. You will hear, I couldn't get in with my doctor. I tried, I'm working on it. And be reasonable. If the person needs time off while you're waiting on the doctor's note, I think that's the right step. Give them the accommodation during the time period while you're waiting on the doctor's note. But if you don't get it, tell them we haven't received it. We need it in 3 days, 4 days, 5 business days. If you don't get it again, then you can start saying, if you don't get this, we're going to deny this accommodation. So denied accommodation, we'll have to think about, does that lead to discharge? Are you going to count the past days missed work as attendance points? Or are you just going to say, going forward, you got to be back at work because we have not substantiated that you were out on work. And if they don't show up, that's when you fire after 3 days. Those are things we can talk about and work through. but just know this is not a quick trigger. You've got 3 days. They don't bring it back in 3 days. You fire. Could we defend that? Maybe. Would we want to? Probably not. Because a lot of this is going to be feeling stuff and being sensitive and being reasonable. And we want to always have the upper hand in that. Must you allow the employees to work from home as an accommodation? That question comes up a lot. We don't have enough facts here to know that. One, we don't know exactly what the job is. Is it a job that could be performed from home? And that's going to be the first question. Could it be done from home? Not, do you prefer it be in the office? Do you just like them being in the office? Is it a job that can be performed from home? I think that's the first question you have. Certainly, if you've let other people work remotely, you're going to be hard to state this employee this job cannot be done remotely. Where I think you have more tools is, does this job need to be worked from home? And that's where you understand the medical condition and what accommodation is needed. If someone gets tired easily, you could say, well, you can come to work and take breaks whenever you need to. You don't need to do that from home. If someone says, well, I can only work 4 hours a day, that's my accommodation I need, then you can't do the job. So we're not going to give you a home accommodation. So where your strength is not, no way, never work from home, unless it's a job like a manufacturing job or a job that requires to be in person. Where your strength in these home accommodations is, do you really need to be at home? Because an important part with ADA accommodations is we don't have to give the employee the accommodation they want. We have to give them an accommodation that's effective. So if an employee says, I want this, but we could make an effective accommodation doing that, then we can go with that and we can propose that to them. And this will allow you to perform the essential job functions. So I think that's going to be an important point of this, is that you are not at their mercy under the ADA. You don't have to give them what they want, when they want, and how they want it. You engage with them, you work towards a resolution that allows them to perform the essential job functions. Number 9, how much time is too much? That is a question we do not know the answer to. It's like the porridge issue. There's too much time. Over years, clearly too much time. A month, a couple of weeks is certainly probably reasonable time off. Where in between, we don't know. It depends on the facts and circumstances, and it depends on the request. I need a month off and I will be back on this date. That's probably reasonable unpaid time off. I need a month off and I don't know when I'll return. Gets closer, maybe you give them that month and reevaluate. I need 6 months off and I don't know when I'll return, even if I'll be better then. That may not be a reasonable accommodation. It's very fact specific, depends on the job, depends on the burden it would impose on you as the employer. And so you'll want to consult with legal counsel on that. But no, there's not an easy answer for that. Unpaid time off can be a reasonable accommodation. How much depends on the facts and circumstances. Number 11, what if the time off extends beyond the probationary period? How do these come up? Employee works a couple weeks and then they're out for a month or two. We don't have any probationary period completed. We don't know if they're a good employee. Can we extend out the probationary period? Yes, you can. I usually like to have this in your policies. If you have a probationary period, we can extend this out or have a practice whenever someone misses a big chunk of work during their probationary period, you can extend it out. But you do have tools to extend out the probationary period if they've missed a good bit of work during that time period. What if the manager, number 12, what if the manager says, I'd rather just separate from the underperforming employee? That's the call we get. We get this fact, and the question is, I just want to separate. It's not working out. This isn't a good fit. That's not how this works. Now, can you separate from an underperforming employee? Sure. Well, what you've got to be able to show is we would have done this absent any medical issues, absent any leave requests. And how do you do that? Documentation. They weren't doing a good job and we documented it. Comparators. We had a same employee, first couple of weeks, were making these same issues, and we let that employee go during the probationary period, and we did the same for this person. Because whether you give accommodation or not, even if you do everything you should under the leave laws, you can still be sued if you retaliate against someone for using their protected rights. So if you say to this employee, take time off, get better, we support you, but at the end of the probationary period say, all right, now's our chance to get rid of this person. You can still be sued for violating the law unless you can show you would have done that absent medical issues or protected activity. All right, so that is scenario one. A lot to unpack there. Let's go to scenario two. Team member Adam has migraines, a chronic condition. He's been approved for FMLA leave, but shocking, exceeds that leave that the certification says he would need for migraines. Now he claims his medication isn't working and is in need of unpredictable time off. I don't know when they're going to flare up, and I'm going to need time off when that occurs. Problem is, one of the issues is employees and managers are complaining he's never at work. Further, he's an underperforming employee. Adam has complained to management previously that he's been passed over for promotion and treated differently because he is Hispanic, but HR was not able to substantiate his claims. And then we'll do an alternative. If this is a female employee who's pregnant, how would this situation differ in our analysis? So what are your FMLA obligations? Adam has been approved for FMLA, and you have to follow FMLA. We are in the FMLA world. What FMLA, and we could do a whole hour-long presentation on FMLA and intermittent leave abuse, but what your tools are at this point is if someone is using leave beyond the scope of the expected leave that's in the medical certification, you can ask for a recertification. So if it says Adam will be out for 1 day a week with migraines, and Adam is out 2 or 3 days a week for migraines for an extended period of time, you can seek recertification. You can go back to the doctor and say, is this reasonable? Is this normal? You said 1 day, he's missing a lot more. Tell us if we need an updated certification so we can handle that. There are other tools for intermittent abuse if that's what you think's happening, but for right in front of you, I think recertification would be an option here. Where this gets problematic is where it's not documented well, how much time off is being used for FMLA. You let it go for a really long time. He's been abusing it for an extended period of time, and only now do you get upset about it. So it's important that your supervisors, HR, monitor the leave usage, compare it with what the certification says. And if it exceeds what's expected, you can ask for recertification. You're probably asking, well, what does that mean, exceeds what's expected? We don't know the exact answer. So it's not Adam's FMLA certification says 1 day and 1 week he uses 2 days. That's not enough to ask for recertification. But if there's a pattern, there's a history of exceeding the 1 day need for time off, then we can get to a point where we can ask for recertification. What are your ADA obligations? This is an ADA case. Likely migraines, chronic, impacts ability, essential job function. Surely anyone who's had a migraine, that definitely impacts your essential job functions when it's active, because that's when you measure an ADA disability. When it's active, how does it impact your ability to perform the essential job functions? So what do you do with the ADA? FMLA has a mechanism to get more information. As we discussed in the last scenario, so does the ADA. So you can still get more information from the employee about condition, duration, impact on work. Now, we always want this to be narrow. We don't want all your medical information. We don't want information we don't need to determine if you're covered under the ADA and you need a reasonable accommodation. Do some employers just say, we got the FMLA paperwork, we'll go with that? They do, and they can. But if you need more information under the ADA, you do have that right. We're not harassing people. We're not being difficult just because they're seeking accommodations. We need this information to make an informed decision. The FMLA paperwork doesn't give us enough to know what we need to know to determine what accommodation could be appropriate under the circumstances. Number 5, does it matter that others are upset about his lack of work? Probably heard this before. It really doesn't matter. We really don't care what other people think about this. And that's hard managing people, because sometimes people can have legitimate concerns. I'm carrying the slack for this person. We've got projects to do. They're not here. What I recommend employers do is, and we'll talk about tools you have for an underperforming employee, but people coming to gripe to you, you can say, we have to comply with the law, and that's what we're doing. And, we have projects we need done, and we're going to make sure those get done, and I will deal with any performance issues. You want to walk that line where you're being sensitive to in some cases, legitimate concerns, but you also want to emphasize that we have to comply with the law, and you don't want to suggest animus. Oh, no, it's the worst. We're trying to figure it out. We don't want to do anything that would suggest we're not happy with Adam's use of his protected rights. Performance issues. This is a hard one. EEOC says you don't have to reduce performance standards, qualitative, quantitative. You've got to do certain things. You've got to meet certain metrics. You can tell these employees who have an accommodation, you still have to meet these metrics. Where it gets tricky are two situations. FMLA, you can't do that. If someone's out on FMLA, you can't hold it against them if they're not hitting their goals while they're out on FMLA. How we would work with an underperforming on FMLA, particularly intermittent, we could talk through, and that would be a longer presentation at another time. ADA, if someone has a short-term duration, I need 2 or 3 weeks off. We don't, and we accommodate them, or we limit their work for a couple of weeks as a short-term accommodation. Those we usually don't want to punish people for not, if you got to hit 20 clients a week as part of sales call and they only do 10 on those couple of weeks where they're incapacitated for extended periods of time because of their medical condition. So these are tricky. They're one of the hardest ones to deal with. I've spoken generally about it. But when you get there, when it's time to discipline someone using these leave, you really need to talk to counsel and think through it, because we've got to do it right. Because you can be certain the employee is going to perceive it as retaliatory. Does it matter he's previously raised concerns of discrimination? Not under the leave laws, but it certainly does under Title VII. You can't retaliate against people who've made protected complaints, even if their complaint has not been substantiated, as long as it was made in good faith. So if someone says, well, they started denying me leave and treating me differently because I made a protected complaint, we're in a different law. It's Title VII, and that's retaliation. So that there was a prior complaint really doesn't matter for the ADA FMLA analysis, but no, it creates legal risk. What if the manager says, I'd rather just separate from this underperforming employee? Talked about that a little bit in last slide. Where's the documentation? Where's the comparators? Where's the record you've built that we can fire this person? And it's not because they missed work, it's because of these performance metrics. And that's what your managers need to know. Your hands are tied until they give you the proper information to take action. And if they don't have it, that's on them, and they need to do it. And how to do that, is another point of conversation, because you can't start picking on someone after they've asked for leave. So you've got to be careful about that process. What if the employee is a female and pregnant, and her migraines are from her pregnancy? I can answer this one quickly. You've got to accommodate. It's not ADA realm reasonable accommodation. Pregnant workers get pretty much the accommodation they want, how they want it, when they want it. Do you have to eliminate essential job functions? Sure. Can you send them home? No, you've got to accommodate. Now, if there really isn't an accommodation, it creates an undue burden, which is a really high standard of proof. Could leave be an accommodation? Yes, but no, if you're in a pregnant realm with a medical accommodation request, you're going to need to accommodate pretty much every time, absent some really unique circumstances.
Yeah, Matt, this is one where I think as cases begin to develop and we get some law, it's probably going to narrow the scope of the Pregnant Worker Fairness Act as we're, making recommendations right now. But I guess what I would say to all of you that are listening is, I don't want to be those test cases. So right now, your best bet is to be very generous in the way that you treat pregnant workers who ask for accommodations. And maybe by this time next year, we can have some different guidance and, be a little bit more aggressive in the way we manage it. But right now, that PWFA is very broad.
Yeah, and that's a great point, because these cases are going to start going through the courts. And again, the courts make the law, not the EEOC. And the courts are going to give us some more guidance on this. So yeah, we may get some more helpful decisions that better guide us on this. All right, we've got 8 more minutes. So I'm going to go through these last couple slides quickly. Scenario 3. Patty worked assigned initially for the staffing agencies, recently be brought on, good record, no issues, but you've learned she takes Oxy before coming to work for a personal back injury. What if this happened when she was still a temporary employee signed from a staffing agency? She will be entitled to the same protections as an employee because you are likely a joint employer of hers. We get these all the time. It's a staffing agency company. Let's send them off. Not our problem. Don't want to deal with this. You have accommodation obligations. You can be sued for disability discrimination. So no, just because if this was just a staffing agency employee, that doesn't change our discussions right now. What else would you want to know? Well, there's a lot you want to know. In our hypothetical, what's a job? What's her condition? Duration? How much is she taking? Is it doctor approved? Sure hope it is. Can she safely perform the job while under Oxy? Those are all things that are fair questions asked and information you can get. We strongly recommend employers, particularly manufacturing employers, have a policy that requires employees to disclose to you if they are on any medication that can impact their ability to work. It's a great tool we have when we learn about incidents after the fact, and it just makes common sense because you don't want someone on a bunch of drugs, even prescribed drugs they need, operating heavy equipment, for example. And so we strongly recommend that all employers have that in their policies. Does her good record factor in? Not really. But we sometimes see cases where someone has worked and not had an issue for a year under this medication, and we learn of it, and we're not happy. That person has been working under the medication, but at the end of the day, we have to determine this person couldn't safely perform the job under that medication. And if they've been doing it for a year without issue, does that bake into the analysis? And ultimately, it's going to be a doctor's call. It could. So I wouldn't completely discount that fact, but it's not going to be determinative that she's been successful in the past. Could you restrict the employee coming to work? We would let a doctor decide that. Now, if you have this really immediate concern of potential harm, you can say, we need clarification from a doctor, take some time off for this, and we could work with legal counsel on how best to do that. But could you restrict her coming to work? It's ultimately going to be a doctor's call. We are not doctors. We don't know how Oxy impacts people's system and how they can work under that. We know what our job duties are. We can tell the doctor, but don't be a doctor. We're not doctors. Let them decide these things because that's going to be a safe spot for you. You may not always get the answer you like, but that's an area of their expertise, not ours. All right. Scenario, this one, employee, probably have gotten these last week of 12 weeks of leave. You get notice that I need some more time. What do you do? A, B, C, D, notify employee FMLA leave's expired and you're going to discharge him if he fails to return. Deny any leave because they've used up all their FMLA. C, tell them to come back to work and require certification, justify additional leave, or allow them to remain on unpaid leave for another month and then reevaluate. Depending on the facts, I think C or D are going to be your answer. When FMLA expires, it expires. And you can clearly state that your FMLA is expired. And when FMLA expires in this scenario, you are now moving into the ADA realm. And the ADA realm, like we talked about, requires accommodations if it's supported by medical documentation. So if that doctor's note is enough for you to give more leave, even though it's unclear for a period in the future, I usually recommend saying, we'll give you a little more time, but we're going to check back in 2 weeks, a month. And if you still don't know when you're going to be back and you need more time and it's indefinite, there's going to be a point where you can say, we can't do this anymore. But I don't want you to pull the trigger too quickly. And we can talk about that. And there's ways to be more aggressive and we can come up with arguments if you do want to pull the trigger quickly. But I implore everyone to think through it and talk through with counsel so you know the risks when you make these decisions. And that medical certification referenced in C, if you needed more, if you just got a doctor's note, needs more time off, maybe you can get more clarification on that. All right, the poor performer, I'll go through these quickly. And these slides will be available. To summarize these next slides in a very simple way, if you don't know someone has a medical condition, then you don't need to know, if that makes sense. If someone's not doing their job, deal with it, address it, move on. If someone tells you they have a medical condition, then accept that and understand it. But if they don't ask for an accommodation, you may not be required to give one. Now, they may not be eligible for FMLA. Now, you could give them the paperwork if they need it, but I want the normal kind conversation of, wow, what can we do for you? How can we help you? Can we do this? You can do that. There's nothing wrong with that. But you don't always have to, and it depends on what you've been told, of course. But these slides emphasize that when people have performance issues, address them and be consistent on them, because when they ask for leave, when they need medical accommodations, everything, as you know, gets very complicated. So with unknown problems, there's little legal protections. Of course, if you see something or if someone calls in, I'm in the hospital for 5 days, medical emergency, you're put on notice. This is an FMLA qualifying condition. So you can't stick your head in the sand. Use common sense. But if you don't know, if you legitimately don't know, you don't know. Unknown restrictions, if they tell you, if they're not asking for an accommodation, then you don't have to give them one. If they ask, then you can work with them. Known disabilities, these are employees with the most protections. FMLA, ADA, all the things we've been talking about. All right, I'm going to kick it back over to Bryance for the last couple slides.
Yeah, so just a couple more slides to kind of wrap this up and help you walk away with some ideas to consistently manage this. So the do's of leave management: make sure job descriptions are accurate. It's really important to have accurate, effective job descriptions so that we're familiar with the essential functions and we can present those to healthcare providers and be confident that these are legitimately essential to the job that's being done. Sometimes HR professionals will draft job descriptions and the job description will change over time. So we have to make sure that we're constantly reviewing and updating those. Do listen closely to requests for leave or accommodation. Make sure that we fully understand what they're asking for. We don't want to get confused. We don't want to get crossways in our interactive process that, maybe we do more than we have to. Maybe we didn't really provide a response to the specific accommodation. So listen closely. Be consistent in documenting performance issues. This is so important in this context that we are, not trying to take action based on a performance issue that we don't have really documented, that we can't support and prove. So make sure that our frontline leaders, our supervisors, are getting that information to you so that you can document it. Treat pregnant employees the same as others. There was a time when we could conclude that you weren't covered by the ADA just because you were pregnant. Those days are over, and it has actually gone, the pendulum has swung very far in the other direction. Report all safety and health issues, making sure that we understand all of the safety implications and the ways in which the employee's disability could impact that. Ensure that those who require accommodation receive it. Look, it has to be reasonable. It can't impose an undue hardship. It's just really, really important in defense of an ADA claim that we can show we were reasonable. We considered the accommodation request and we did the best we could to put our employee in a position where they could perform the essential functions of the job. Even if, we get some things wrong or, the court might think there was a better option available, if we can show that we used a reasonable approach and we provided what we believed was necessary and appropriate, we're going to be, in pretty good shape on that. What are the don'ts of leave management? So, first of all, never disclose employee medical information to anyone who doesn't have a need to know. And that really is limited to the person who's making the decision about whether an accommodation should be made or not. And you don't have to talk to your frontline supervisors about the specific medical information to make that determination. So limit that to only the people who have a need to know. Don't be a doctor. Don't make assumptions about medical conditions. Let the doctors make those decisions. In a lot of situations, the doctors will, frankly, go too far with some of the restrictions that they place on employees, the conclusions that a job needs to be changed for an employee, so let them do that. And then we can make a determination that, well, we don't have an obligation to modify this job, or you just simply can't perform the essential functions with all these restrictions and there's no accommodation that would enable you to. Let the doctors be the doctors. Don't overlook potential requests for accommodation. Look for those in whatever form they come in. train your supervisors to hear and understand what is a request for an accommodation so that we don't end up in a situation where we didn't engage in an interactive process because we didn't know we were supposed to. Don't make medical inquiries of applicants or employees. We focus on the performance issue. If someone is not doing the job and we think it's because they have a medical condition, we're focused on the fact that they're not doing the job. We let them respond with, well, it's because of my medical condition. So we're not making medical inquiries. We are letting them drive that, and we're focusing on the performance issue until it becomes about the medical condition. Don't alter the essential functions. You know, this comes up sometimes in the workers' comp context where we've created a light duty job to comply with some workers' comp obligations, but we don't make it clear that this is temporary and that the job is still the job and that the employee is going to be expected to perform it. Don't make alterations to the essential function as an accommodation, because that means that's the job now. And we're stuck with it as the way it's constructed. Don't count absences that are covered by FMLA, ADA, other leaves against an employee under the attendance policy. That leave is protected. That leave is not subject to, penalty based on an attendance policy. We see a lot of times employers with no fault attendance policy. If you're not here, it's a point, okay? That is not permitted when the absence is qualifying under the FMLA or the ADA. We have to be very, very careful about that, because that can be, an interference claim or a discrimination claim under either one of those statutes. And then finally, don't tie performance to medical conditions unnecessarily. And that's what I was just kind of getting at. Focus on the performance, the inability to do the essential functions of the job. We don't know the reason. We don't care what the reason is. You're not getting the job done. That's where our discipline or our counseling comes into play. And then if there's a medical condition that becomes part of that, we're not the ones that are focusing on that. We are not tying performance to medical conditions unnecessarily. All right, we're over our time, but I think that was the last slide. Yeah. And because I'm such an efficient lawyer, I was able to answer some of the questions in the Q&A in the chat while Matt was talking. And I think I've knocked most of those out. But if anyone has anything else that they want to ask, I see one. Can you provide sample requests for additional documentation from doctors? And we can. I'm not sure who asked that question, but if you're looking for that, if you will just email Matt or I, we can talk through some of that template type forms to get additional information. I will say it's not one size fits all. Usually it's going to need to be tailored to the particular issue. But feel free to reach out to us on that question, and we'll be happy to provide you some information. All right. So I see someone said this was a really good refresher. Yeah, that's what this was, right? I mean, most of this stuff is not information that you folks haven't seen or heard before, but we think that it's important to kind of go over, consistently, regularly, how all these things interact. I'm going to tell you, I've been practicing law now for 28 years, and it continues to confuse me on a day-to-day basis, the way these laws interact. The FMLA regs are so complex and nuanced. And so, I don't think any of us should ever believe that we are, fully educated on any of these laws, because they're just constantly evolving, and we need these constant refreshers to remind us how to manage some of these issues. That's all I have. If there are no other questions, Matt, thanks. And for everyone that attended, we really appreciate you being with us. The slides will be available to you, and as I think someone noted in the chat, this will be on YouTube. It's recorded, and so if you want to watch it, if you want to send it to someone, within your group or somebody that you're friends with outside your group, feel free. I mean, we're presenting this so that everyone can be educated, and we're happy for anyone to see it. So thanks for your time this morning, and we all hope you have a great weekend. Thanks.
Thank you.